Hello, everyone. Welcome. I know there's a few still coming in, and we want to allow time for that, but I just want to welcome you so I don't hold you over on the final panel of the day. Congratulations to everybody for getting through a marathon 3 days. It's been really fascinating information. I hope that we add to that and you enjoy this. I'd also like to thank all of the panel organizers and the conference organizers for all of the work they've put in here. I know it was a big undertaking, and it's been wonderful. For a very quick introduction, my name is Callie Schrader. I'm EPIC Senior Counsel, International Counsel, and head of the AI and Human Rights Project for the Electronic Privacy Information Center based in Washington, D.C. The panel that we have today is on AI and elections. We have been doing a lot of deep research into this. AI is intersectional in a whole lot of areas, and elections is no exception. So I want to dive into a few of those ways just as setting background before I turn to our brilliant panelists. This panel is focusing on some of the AI-specific harms that we're seeing in elections. So frequently we will see mis and disinformation. That can be about candidates themselves, text, audio, or video fakes of candidates doing things they didn't actually do, saying things they didn't actually say. It can also be about the election process itself. So we've seen some very convincing misinformation where, for example, President Biden was calling people and telling them not to vote in the primary. That was not President Biden. So those are two angles of mis and disinformation we've been seeing. We have also seen serious data security issues when it comes to AI involvement in elections. Some of this is that it enables more sophisticated hacking, but we will get into those details as well. There are issues with foreign interference. AI is enabling people to very, very convincingly present themselves as native speakers of a language. That can make misinformation campaigns or foreign interference campaigns much more believable and effective. It can also spread them much, much more quickly. And finally, in general, the speed and scale of the spread of AI-generated harms and information has been escalated to an astonishing degree through this technology. That's enough as background setting. There's a lot more interesting stuff that we're looking forward to getting into. And for that, we have three brilliant panelists here. Rather than me going through and introducing them, I thought it would be a little more interesting to have them introduce themselves. So for each of you, just going down the line, I'm going to have you give us your name, give us your position and affiliation, and please explain how your work and your history interacts with AI, elections, or both.
Hello, everyone. My name is Maria Villegas Bravo. I work with Callie at the Electronic Privacy Information Center. For a little bit more context, we are a US-based organization founded in 1994. We do research, advocacy, and a lot of litigation support, and we do this in a lot of different areas. Right now, our two of our major project areas are artificial intelligence and human rights, as well as platform governance and content moderation issues. So a lot of our work right now is centering on this. I'm personally working mostly on the international side with Callie here. I do a lot of artificial intelligence work, as well as reviewing a lot of the AI Act, doing also some surveillance oversight work. In particular, recently, EPIC recently published the Generative AI Report Update. If any of you read Generating Harms a couple years ago, we just put out a report discussing AI and elections and a couple of other harms that we think are continuing to pop up, so if that is of interest to you. And then
So thank you very much once again for the invitation. I'm Elinor Val. I'm a legal and policy officer in the European Commission. And in particular, I work in the unit that is working on AI policy development and coordination. This is notably the unit that has drafted the AI Act, which was already mentioned 2 minutes into the panel. We also, of course, work on other broader range of initiatives on AI policy. And of course, in general, we do quite a lot of our work, I would say, covers and interacts with the topic of the use of AI on elections, the risk for misinformation when it comes to AI, generative AI. So very happy to be part of this discussion today.
Hello, my name is Cornelia Kutter. I'm the managing director of Considerati, which is a legal consultancy specialized in data protection compliance and AI governance compliance. I'm also a researcher at the Multidisciplinary Institute in Artificial Intelligence of the University of Grenoble, focusing on legal implications. And I am part of a smaller NGO, Safer AI, that looks specifically at AI safety risks. And the background to that specific topic, before all of that, I was for a very long time the head of the responsible tech and competition team of Microsoft here in Europe, which amongst other things was dealing with disinformation, the DSA, AI Act, DMA, and many other topics and rules.
All right. Now that we have a little background set, I want to dive into some of the big questions. Just for reference, I am reserving quite a bit of time for audience questions, so please be thinking of those as we go. Oh, I am so sorry.
Oh.
Thank you, Colin. We do have one remote speaker who is joining us from Canada. He very graciously agreed to come across time zones to join us here. I will turn to Colin for his introduction.
I thought you'd forgotten about me for the moment there, Callie. Yeah, my name's Colin Bennett from University of Victoria in British Columbia, where I'm speaking to you now. I am Professor Emeritus in Political Science and also a Fellow of our Center for Global Studies. For about 12 years now, I have been thinking and researching on the question of the use of personal data in elections and how privacy law, data protection law intersects with political campaigns. And I've also been an advocate in Canada for a better set of rules for our political parties here. And so I bring, I think, a bit of a comparative perspective. I'm a political scientist, and I've been thinking a lot about how you strike the right balance between, on the one hand, the legitimate needs of political parties and candidates to communicate with the electorate in a valid and responsible way, as well as protecting the privacy of voters. So I'm glad to be here. Thank you.
Perfect. Now that we have gone through all of our speakers, I wanted to turn very quickly to a fairly broad question that I think gets into some of the specialties we have here. Represented, we have civil society, we have government, we also have people that have deep knowledge of technology, sociology, society, data compliance, working with clients, and through all of those perspectives, I'm hoping that we can have some discussion about where all of these challenges are and whether it's possible to adequately address all of them, particularly in a year that has 64 national elections happening in it. This is a pretty significant issue. So the thing that I'd like to start with is, do we consider the risks that we've seen from AI different types of election harms? Is AI causing new things, or is this just an expansion of issues that we have seen before? And anyone that is interested in starting that, please feel free to jump in.
I guess if no one else has an answer, I can start now. What we've been seeing at EPIC is that this really is just an expansion of what we've already been seeing in past elections. In particular, AI has the power to really accelerate and turbocharge a lot of these harms that we've been seeing. So first, it is big on scale. You can generate so much content at such a low barrier to entry and at such speed that the amount of content and information on election issues has been insane. It's hard to keep up with, millions of posts. And not only in terms of the amount of content that's being created, but as well as the amount of scam, fraud, other schemes that have been coming up. For example, there's been over a 1,200% increase in robocall fraud, and a lot of that recently has been election-related, as with the Biden robocall scam in New Jersey a couple of months ago. And so there's scale, there's believability in particular with generative AI and synthetic content. When you see a deep fake of a person, you don't automatically think, is this real, is this not real? Especially with the higher quality content that's coming out now, it's very easy to just look at that and not notice. It's very persuasive, especially as these are getting more and more powerful and better high quality outputs. And of course, with the barrier to entry, anyone can use the old ChatGPT models for free. Anyone can find these open source models. So there's no stopping anyone from getting into this situation.
Yeah, I would agree that this is an exponential increase in the same risks. What is eventually new is that we have different players in the space. So I totally agree with the democratization of the tools. I think there is differences, for example, when you talk about these types of risks and biorisks, for example, that might be democratized as well. For biorisks to realize, you still need physical and analog things, products, and a bit of know-how on how to put them together. Here, this is becoming on a daily basis easier. At the same time, however, I'd say the same players are those where the content is disseminated. So this making publicly available still happens on the social media sites and not necessarily within these new players, the AI labs, which is more one-to-one conversational, which brings other risks, but I just wanted to say that too.
I would like to ask Colin if he has any specific feedback on that, partially because I know he has looked at societal impacts, and in particular, not only do you have any response to that, but are there any risks that are at a broader societal level that we are not focusing on that are AI specific or hugely exacerbated by AI? Not to put you on the spot.
No, that's fine. I think this debate is occurring at a time when democracy is under threat and democracy is in decline. Just one piece of data which I find compelling. According to the Freedom House stats on freedom and democracy and measures of democracy, in 2005 there was 46% of the global population that were living in countries that were generally classified as free or democratic with the general measures. 2022, that figure was 20%. So we're looking at a situation in which AI and all of the other techniques of digital campaigning have entered a system, has entered a condition where democracies are less trusted and the institutions of democracy are less trusted. Fewer people belong to political parties. This is a global trend. There's less partisan allegiance than there used to be. So what that means is that in pretty much every country, there are larger proportions of the population that are susceptible to influence and manipulation. Gone are the days when large numbers of people vote the way their parents did because their families were that family, right? So I just throw that out because I think it's important to see this in that larger context. And all of that, of course, produces a decline in trust in elites, but also a decline in trust in democratic practices. There's some really troubling data in Europe which suggests that more and more people are willing to embrace more authoritarian forms of governance than they used to. So into this environment, well, comes social media. And you know, if you look at that trend, 2005, democracy was looking pretty good. Well, Facebook arrived on the scene about that time. Now, it's difficult to ascribe cause and effect, but it's difficult, I think, also to reject the argument that digital campaigning, social media, micro-targeting, and now AI hasn't got something to do with that general decline.
Great, thank you for that. So when we're looking at the problems that we're seeing from AI, specifically related to elections, I wanted to ask the panelists, do you think the existing regulations that we have are capable of addressing these problems and there's just an enforcement issue or some sort of intimidation when it comes to technology? And for that, I'll be more specific about the regulations I'm talking about. For example, Eleanor, do you think that the AI Act or the DSA are capable independently or together of addressing these issues?
This is a really great question, and indeed, the very first thing that I wanted to mention here is that us in the AI and the AI Act team are working a lot together with our colleagues that are working on the enforcement of the DSA. We're working quite a lot with colleagues in the European External Action Service. We're really trying to streamline this work because this is extremely important in this case in particular. And in particular, once again, in this year where we have so many elections and the European elections as well. The AI Act is also a piece of legislation that tackles the risk of misinformation and disinformation in the context of elections. And I feel like sometimes it is, I think, relatively well known that there are specific transparency requirements that are extremely relevant in here, and that is of course very true. But at the same time, I think the AI Act covers this risk in much broader ways. So maybe I'd be happy to give a very short overview on the specific ways in which the AI Act covers it. So you probably all know that the AI Act takes a risk-based approach. So the AI Act identifies 4 different risk categories, and it provides different level of provisions and obligations according to the risk level. In every single risk category, we have and we can find some provisions that are relevant in the context of AI in elections. So if we start from the unacceptable risks, so all of these AI systems that will be completely banned from the EU market once, of course, these provisions enter into applicability, we have the complete banning of biometric categorization systems that are aimed at inferring the political views and political perceptions of people. And this is something that is extremely relevant. We have another category that will be banned because it will be deemed unacceptable in terms of the risks that it varies. And these are AI systems that are intended to manipulate people and to exploit people's vulnerabilities. Once again, this is extremely relevant also in the context of manipulation of voting behaviors and on voting patterns. We then have the category of high-risk AI systems. This is also one of the core categories of the AI Act, I would say. And in that case, we have, among the cases that have been included in the high-risk categories, we have those systems that are intended to influence voting behaviors, as well as the outcome of an election. So in that case, these types of systems will be permitted in the EU, but they will have to comply with a very specific set of obligations and provisions to make sure that those AI systems are fully in line with our democratic values and our transparency values that we have in the EU. And then finally, we have the category of transparency risk, which is probably the best, the most well-known, I would say, in this respect. But nonetheless, I think it's important to remind what it is and why it's relevant. So the core idea behind this, more broadly, even beyond the topic of elections, is the fact that people should be aware whenever they are interacting with a content that has been generated by AI. So this is really the key principle. People should be informed so that they can make an informed decision on whether or not they want to continue engaging with certain types of content. And of course, this is extremely relevant in the context of the elections and electoral processes because deepfakes have been quite a prevalent phenomenon so far. The AI Act covers the use of deepfakes, and it mandates, actually, those deepfakes to be clearly labeled as such. So this is really an important principle that is included in the AI Act. And then there are other requirements to facilitate the detection and the identification of AI-generated content. So be that text, images, audio, etc. So everything, all of these principles really go into the direction of providing a safer and more sound democratic process on the internet as well.
One thing I do want to push back a little bit when it comes to the AI Act is, in terms of the high-risk category when it comes to AI systems that may influence the outcome of elections, the wording on that piece is that it has to be intended to to influence the outcome of an election and be placed on the market for that reason. Right now, what we're seeing, the generative AI systems that are causing these harms would not fall under that necessarily because of the general purpose of these models. These are general chat GPT, it is LLMs, it is DALL-E, it is all these other more general purpose or things that may have been intended for other reasons, creating deepfakes or other reasons. So in that case, they would not be covered by the high-risk category. I do agree that there are a lot of amazing provisions in there about generative content, but I do believe that there are some gaps in the AI Act that may not cover this.
So moving from AI Act specifically, or expanding into many other areas, because as we've seen, I'm going to put Colin on the spot again and ask if Canada's C27 omnibus bill would cover some of these harms. But before that, I was wondering from Cornelia, in your experience, do you think that there are other regulations that can maybe as a patchwork cover some of these problems? Maybe a combination of like consumer protection law, privacy and data security, platform governance. It seems like because there's multiple angles to the problem, it could be something where multiple angles of enforcement could address this.
Yeah, I mean, first of all, there is a patchwork that applies to the situation. There's obviously the AI Act with some transparency measures. In the AI Act, you have also CPDP.ai rules. It would take an hour to go through this. It's an interesting way of describing systemic risks here, which is bound to the high impact capability of the model. I don't think they're necessarily entirely related, but there's a reason why this came together that way, and I can go into this a little bit more. Which brings me also to another issue, because there is this FLOPS threshold, which is sort of compute power threshold. The reason why we have that comes from a debate that is very much related to existential risks and long-term risks, where governance researchers have identified compute power as one way to regulate it. Either at the compute powers or at the data center level or at the chips level. And I think that is actually really interesting to think about in terms of the stack in the DSA. So this would be the other obvious rule book of the European Union, the Digital Services Act, where election and misinformation is a systemic risk for flops and flosies, so for the very large online platforms. That does not necessarily include then the AI labs and the model providers. They are not necessarily covered. They might be covered if they are a part of a search engine, for example. That again is potentially some gaps here, because this 45 million threshold in the Digital Services Act is very much tailored to the social media platforms, so where the dissemination is really the main vector. But what we are seeing here with the deepfakes is that they can be built at the platform level. I consider OpenAI a platform. This goes a little bit to in which direction are we actually going with the technology. We will see a platformization with agents on top of it. Some parts of that already exist. There's a lot of research going on in this space, and that multiplies sort of the players that we are not covering by either of those regulations. And that is where a lot of the deepfake production is going to happen. Then you might go back to the users that have malicious intent, that then they circle it back to social media. And when we are at this stage, when it circles back to social media, then we are at the question in what is actually effectively be done to detect deepfakes in this space. And here again, it's going to be a technical problem in finding with the right technology quickly enough deepfakes, and what is a deep, when it is not, when it is a question about freedom of expression, freedom of information. So what we are then seeing in this space is literally the same debate we've had over and over, and now go just 5 years back on content moderation and takedowns. We haven't really solved anything. So that is where there is debates at a European level, you know this much better than I do, around the structural indicators, and can we actually measure any success of the commitments that have already been done at the level of the code of practices that are already existing. And I think there are a couple of new codes and new tech accords where companies, the big companies, develop and commit to certainly really good things they do. And I stop here because there are a couple of things they do that are really good, maybe for the next round.
I definitely want to dive into some more of that. One thing that I'm taking away from that is that it sounds like part of the problem with regulation in general is that the typical categories and players that we've seen are no longer consistent, and the lines are kind of blurring between them, and new players are emerging that haven't fallen into our typical regulatory structure. I do want to dive more into that, and I'm going to, but first I was wondering what Colin's take is on Canada's C27 omnibus and whether there are similar issues that Cornelia raised appearing in that discussion, whether he believes that that regulation is going to address the problems or whether there's similar or additional existing gaps there.
Yeah, thank you. Well, despite all the concerns in Europe about how your various regulatory measures will work, I think the general perception here is that you're way ahead of us on these issues. I don't want to get into any depth about what Canada's been doing here, but there's an omnibus piece of legislation that's going through the Parliament at the moment, which is both an update and a modernization of our private sector data protection law, PIPEDA, as well as AI regulation. And there's a lot of us who believe that those things should be decoupled and that the AI regulation is not fit for purpose, and it's certainly not as strong as the EU AI Act. And it's not even clear to me that how it would affect this debate that we're having now about elections, because it's really just focusing on commercial organizations and the accountability and the risk assessments that need to be done there. I do want to make a point about misinformation and disinformation, however, because I think it's a mistake to just focus on that. I understand how important it is. And we also are debating an online harms bill and also a transparency register for foreign actors in our elections. And it's all a bit late, it's all a bit defensive. But one of the other things that I think is important to keep in mind is that how AI affects legitimate campaigns, how AI affects candidates, political parties who are using those tools in combination with existing profiling systems for the electorate through voter relationship management systems in order to micro-target categories of electors. Now, what we found, I think, generally about micro-targeting, although it's incredibly extensive in the United States, I think it's a mistake to generalize from the United States to other democracies. I think it's sui generis. There are a load of reasons for that. Your campaign financing system, your First Amendment, which has these robust protections for political speech, etc. But in other countries, you find that micro-targeting is there, but it's far less extensive. And the reason for that is because of the costs of content creation. It's okay to identify a group of people who might be susceptible to a particular message, but you also have to create the content in order to influence the vote one way or the other, or to not vote. And that is a real constraint in countries like Canada, as well as in many European countries. Now, AI, of course, reduces the costs of content creation, as has been mentioned, reduces it dramatically. So I'm going to be interested to see in the upcoming European elections, the UK election, and our Canadian election next year, the extent to which the advent of AI tools and the use of generative AI and those platforms will, in fact, increase the amount of content that is integrated into existing digital campaigning tools that are fueled by existing profiling systems. And that's, of course, where the robust enforcement of the GDPR, other data protection rules really, really should play a role. Political opinions are special categories of data, and our DPAs need to be very, very vigilant about that.
Thank you. I think that that is an area that gets overlooked quite a lot because people, at least in civil society, tend to be so focused on misuses of artificial intelligence. You forget that there are many valid uses and uses that are expanding from the candidates themselves and that are very deliberate in that way. And in addressing what Colin raised about how US elections are distinct in many ways from other democratic election systems, partly because of the structure, partly because of the finance, partly because of the length, frankly. A US election season is extremely long compared to a lot of other countries. I'm going to turn to Maria to talk a little bit about some of the challenges we have in regulation in the US. And I know that it's not only frequently referred to as a patchwork, but also may run into the similar problems that were raised earlier about how there's category blurring there. Would you like to speak to that?
Yeah. I'm sure as many of you know, the joke in the US is kind of, why have one law when you can have 72 laws? Right now, we're dealing with such a patchwork of issues. Honestly, the only on-point laws we have on AI and elections is some state-level deepfake and election laws, and that's mostly political advertising law, essentially, where if candidates are using these deepfakes for their political advertising, they have to disclose that fact. But many of these state laws are very transparency-based and nothing else. There's no prohibitions, there's no anything like that. I believe Public Citizen has a tracker of these state-proposed AI laws, but other than that, there's nothing exactly on point. We have other laws like the Federal Communications Commission, our telecom regulator, has some laws on robocalls and some laws on impersonation of businesses. Actually, I believe that one's Federal Trade Commission. It's all the same letters. But all these like little laws that come together to get at pieces of AI and elections in the United States, but none of them particularly hit the whole issue. They don't address the issues of misinformation and disinformation. And part of that is because of the First Amendment and our free speech and free expression laws in the United States. They're particularly strong. And right now they're the biggest barrier to getting any kind of content moderation issues up right now. So the first kind of issue I'm going to get into in terms of the United States is Murphy versus Missouri, which is a case that's going on right now. It just had oral argument in March at the Supreme Court. And essentially that case is whether the government, the United States government, can tell social media companies whether or not they can, like, if the government gives them information about election issues or COVID-19 vaccine information in this case, whether or not that is forcing these companies to content moderate, which could be a First Amendment violation. And so in this situation, it's unsettled whether or not they're allowed to do that. The First Amendment covers not only free speech to say whatever you want, but it also stops the government from telling you to say something. It stops compelled speech. And so right now, a couple of social media companies have sued the United States government in Murphy versus Missouri to try and settle this issue. So it's up. Right now, we're not sure how it's going to come out. The Fifth Circuit, I believe, came out on the side of the social media companies telling the government that they are not allowed to do this. Even if the government is not requiring these social media companies to do any kind of content moderation, they just gave the information about COVID-19 vaccines. The social media companies are still arguing that there was a coercion or a power dynamic there that would maybe require, like, even if it's voluntary, it might require them to do something. So in that sense, that is one major roadblock to content moderation issues. And the other major roadblock is our good friend Section 230 of the Communications Decency Act. If you know what that means, I'm so sorry that you also know this. But essentially, Section 230 of the Communications Decency Act blocks liability of content platforms. The United States cannot tell platforms what content to moderate or how to moderate content just because there's a safe harbor for them. It's a very complicated issue, so I'm not sure I'm going to be explaining this completely correctly, but essentially, the platforms, we want to incentivize them to moderate on their own, but to do that, we're not allowed to tell them what to moderate, because if they do some moderation, but they don't do it right, if they don't do it enough, if there's still some kind of issue, if there's some kind of wrongful death, they do not want to be liable for that. So if we give them a safe harbor, the argument is they'll be more likely to do more moderation on their own. So right now, Section 230 gives them that block. It was supposed to be a very narrow rule that only protects in certain circumstances, but right now tech companies are trying to use Section 230 safe harbor as a very broad overview to block any kind of content moderation, block any kind of regulation from the government on online safety regulation. So there are currently several court cases up in the Ninth Circuit, in the Supreme Court. The big ones you want to look into are anything related to net choice, X v. Bonta, net choice v. Bonta. That was a lot, but the United States is having a very fun time right now.
I think that that's raised a whole lot of issues in discussing what is and is not covered, and some of the particular challenges we're having in trying to address these harms. To build on that a little bit, I want to ask what may be a very, very basic question, but is regulation the right approach to this, or is regulation the only approach? Is there a possibility that there could be technical solutions, voluntary commitments, other actors involved in this discussion that may be a more essential part of this? Are we being a little too blinkered and focusing solely on regulations?
I can start. I absolutely think that regulation in this space is necessary. Having been in this space for many, many years, there is so much that companies want to do, but I don't want to underestimate what they want to do. So in a company, everything is obviously focused on the acceptable use cases, and so there's different pressures that companies are confronted with from different ends of the spectrum of stakeholders, and so they want to try the middle way. They also it also depends on the specific service, because they tailor services to a specific audience. So if you have a more professional social network, then you have different ideas of how you want to protect that community. Or if you tailor your services to children, you might want to, your trade-offs between freedom of expression versus safety will look different from eventually a social network that tailors to everybody, or, for example, vis-a-vis a search engine, right? So there is all these trade-offs that you have to do, and they are certainly not easy to make. They bring you so far, and they are not related to a specific environment or specific jurisdiction either. And it's interesting that you mentioned Section 2030, because I think for the longest time that I've been in this space, there was just no coming together between the United States on Section 2030 and the European idea of freedom of expression, and not freedom of speech, freedom of expression, ends at a certain moment where it interferes with the rights of others. And I've certainly, with colleagues in the United States, for a very long time had this debate, and it was clashing. But this has entirely changed. So the whole conversation around Section 2030 in the United States has changed. And of course, over the years up to the Digital Services Act, there has been a lot of movement in Europe too. But I want to, in this context, say something about different other areas that intersect with that. What we have seen, for example, in this space, that it was very much so in the DSA space, was very much dominated by IP rights owners at the very beginning of the e-commerce directive that were very unhappy with the liability exemptions. We didn't talk so much about children's rights at the time. This came as this became a bigger and bigger issue. So, and I think we are seeing a little bit the similar situation now again with AI, so that certain rights are more prominently discussed than others. So I think that is something where I'd always say, look a little bit on the side when we talk about elections. Maybe think about what, how does this relate to deep nude, revenge porn and all these issues, and how can we learn from each other, both from the regulatory aspect but also from the technical aspects. There's obviously different technical issues, bring the experts in at the table, and ultimately, and this is something that brings us a little bit, deviates eventually a little bit, but I think it's absolutely important when we think about the responsibility of model providers. We have obviously, even within the AI Act, one of the biggest, I think, gaps or oversights that were done, that there is for generative AI or for the general purpose AI models, no access rights for researchers that we have actually in the DSA. So now researchers can look at those flops and flosies that use AI in their spaces, but it's very limited. The rest of the general purpose AI models cannot be looked at, and in this space, I think the data sets are the most important baseline. That is just for those services that we are really talking about, but we might also need to think about, and this goes a little bit to Section 2030 as well, we need to think through the whole ecosystem, the whole value chain when we talk about the responsibilities, and that is eventually something that, again, the DSA doesn't do, but they, thinking about how these interrelate, the tech stack, and how we can better distribute the responsibilities.
Yeah, on my end, I fully agree on the value that regulation brings in this, especially because regulatory interventions also bring a lot of clarity for organizations that are active in this field. And especially right now in the field of AI, this is really needed. So that was really my first point, completely agree on that front. The other point that I wanted to make is also the need for international cooperation and coordination on this, because when we're talking about especially technologies that are by their very nature not physical, and those that don't really stop at borders, we also need to confront the challenges that come along with this situation. So this is something that we are extremely aware of in our team and in the work that we do. And in particular, I wanted to remind the work that we do in the context of the G7 Hiroshima process. So in there are specifically the guiding principles on AI and the code of conduct on AI, which specifically go into the direction of making it easier to identify and to detect content that is AI generated. And the idea here is really to have, to achieve at least an international consensus on the key principles that we're working with when we talk about AI and misinformation and disinformation. So I think this is also one of the key points and the key challenges to an extent that we will face in the future. So stepping away from discussing, let's say, individually the impact of AI-powered misinformation in Europe and then in the US, in Canada, in other countries, and really having a conversation at a more global level, I would say.
I would say in this situation, I do put my skeptic hat back on. In the past couple of months, we've seen companies over and over again just gut their trust and safety teams. Left and right people are being fired from these teams, and allegedly these duties of trust and safety have been reorganized and shuffled around, but I really do believe there's a really big issue with the companies saying that they're self-regulating. They do just enough, in my opinion, to say that they are doing some kind of content moderation. Maybe there are community labels on X, formerly known as Twitter. Maybe Facebook is doing some flagging, some labeling. However, I don't believe that's truly enough to meaningfully actually get at these election issues. I don't believe any one solution is the way to get at this, but I do believe that at least some regulation or some obligation on the part of these companies from an external force is necessary to get this moving along.
Colin, if you'd like to speak to that, please feel free to. I'm going to throw one additional question in the mix just in case, give you some options. So we're both looking at whether there are additional solutions on top of regulations. I am also curious about, we've raised a few times that there needs to be much more conversation internationally between coordinated efforts. There also needs to be much more coordination between different industries because AI is such a cross-cutting and multifactorial system that you can't have just attorneys talking about how to deal with AI. You can't have just government people. You can't have just technologists. And frankly, at this point, those aren't even the only categories. You also need to bring in sociologists and ethicists, and you need to bring in people that can study elections themselves and social impacts. So I'd like to ask you both whether there is something besides regulation that you think needs to be part of this process, and who you think needs to come to the table, and what conversations we're failing to have in this space.
Yeah, thank you. Well, what I was going to add was, yeah, this is a global problem, and yes, it deeply implicates the larger issues concerning platform governments and content moderation, and all of that's very important. But elections are different, right? And I think we have to remember that although the technology might be the same, the effects in individual countries are likely to vary in interesting and important ways, depending on the political culture, the political institutions, the party system, the electoral system, campaign financing, general traditions of campaigning, levels of trust, all of these things that are deeply rooted in history, right? Deeply rooted in historical traditions about what people expect of their political actors. Now, with that in mind, the competitiveness of elections, I mean, leaving aside the malactors is a huge problem, but the competitiveness of elections and leveraging the natural competitiveness of political parties and candidates in different countries is an important part of the solution, I think, because we have to get to a place where none of them find this acceptable, where they all agree that this is completely unacceptable in order to protect the integrity of democratic institutions. And I'm afraid that what you see at the moment is politicians, certainly in my country and elsewhere, sort of putting a blind eye to this, saying, okay, well, we're sort of being helped by that disinformation. We're being helped by that deep fake. So sort of let's not say anything about it. And so we need to get to a space where they all sort of agree that this is completely wrong and not only needs to be regulated, but also needs to be agreed as being completely outside of the bounds of responsible political discourse. Now, whether that's in the terms of codes of conduct, so that the political parties and the candidates and others are calling each other out when they see this happening. And it becomes part of the general process of electioneering. And with respect to, and again, I just sort of reiterate what I was saying earlier, that there is a, there is a US environment here, right? And I mean, this is a pattern, and it's different because of your First Amendment and other things about your system. But there's also a set of issues that are, I think, quite peculiar to parliamentary systems and multi-party democracies, etc., which needs to be kept in mind in this global conversation, if that's what we need.
I think that's an interesting way to look at it, particularly because we so often talk about just general democratic systems and fail to realize that within that broad category, there is a lot of very significant variance that is affected very specifically by this technology. So I think that's a good thing to keep in mind. I promised I would leave time for audience questions, and I can already see that we have a couple. Please put up your hand if you have some. We'll take a few at a time. I can see Baron back there has one, and one over here. If anyone has a mic to run, let me know. Otherwise, I can. Thank you. One back there, one over here. Thank you.
Hi, Baron Soka. I run a think tank called Tech Freedom and am a First Amendment lawyer. So I just wanted to clear up a little confusion about the Murthy decision. That decision did not side with the platforms. That decision was brought by a bunch of very right-wing plaintiffs who alleged some, frankly, insane claims about the Biden administration supposedly coercing the tech platforms. The Fifth Circuit agreed with them on essentially fake facts and found that they had been, the platforms had been coerced, and that if that were true, that would trigger the First Amendment. So that case is now before the Supreme Court. And the question is, what is the standard by which we assess whether coercion has occurred? And of course, it's possible that the government could coerce a private party, and that would trigger the First Amendment. And if the government forced a private platform to take down misinformation, that would be something that would be restricted by the First Amendment. There's no evidence to believe that that coercion actually happened in Murthy. So I just want to make clear that Murthy actually, to me, and the Fifth Circuit's decision, is an example of the far right in the United States attacking any effort to moderate content, and in this case we're talking about misinformation about vaccines and COVID. But moreover, it's an example of the judiciary having been corrupted to the point where you have a bunch of Trump-appointed judges on the Fifth Circuit, and maybe some justices on the Supreme Court, who will buy those arguments based on completely made-up facts. So that's the issue before the Supreme Court now. And it leads me to the second point, which is you're not really talking about the elephant in the room in the United States, which is that the American right is not only diseased intellectually by misinformation and conspiracy theories, but they are now waging war on content moderation in order to keep private companies from moderating that content. And in the United States, that moderation has to be done by private companies because of the First Amendment. It's not something that the government actually can restrict, because essentially all of this speech, no matter how false, no matter how harmful, is protected speech. So we need private parties to do that. It has to be done through private ordering. It can't be done through public law, as it could be in Europe. And that leads me to my final point, which is that Europeans like to talk about Section 230. There's a lot of misperception in Europe that Section 230 is somehow to blame for a lack of content moderation in the United States. In fact, Section 230 is a shield that protects these private companies when they moderate content. And right now, it's the far right in the United States that is attacking Section 230 precisely because they can't attack the First Amendment directly. So they are trying to remove the immunity that protects private companies when they moderate content, because they want to use the American legal system, which is the most expensive in the world. They want to weaponize that system to harass private companies, to get them to stop moderating content so that they can spew misinformation and spread lies about elections and COVID and so on. So I would just submit that your panel really ought to consider that the real threat in the United States, where these companies are driven and are generating these services, is really coming specifically from the far right, unfortunately enabled by some people on the left who also think that Section 230 is a problem and really don't understand the consequences of what is being proposed, that we cannot regulate this content in the United States directly. The best we can do is have civil society and advertisers put pressure on private companies to be good corporate citizens and to take down this content. They are doing that today. They're not doing it as well as we would like, perhaps, but the situation would be far worse if they faced legal liability for removing content that, again, is protected by the First Amendment that they want to take down today.
I'm going to have the mic come to a question in the front row here and then one right over there. While that's running over, I will note that I agree that it is a much more nuanced situation on Section 230. There is a lot of partisan issues going on there. I wasn't sure about weeding into the weeds of the political nuances of the U.S. because, let's be honest, even after the insurrection, that it's very messy to wade into, and I didn't want to derail the conversation. I do think that we can get into, if anyone wants to respond, once we take these other questions in a broader level on content moderation and those challenges, please feel free.
Hi, thank you for bringing up this cross-sectional interdisciplinary committee. My question is three-dimensional. Approaching all. So first of all, I would say Section 230, when we are talking about Gonzalez versus Google, shows clearly that there is no scope. Probably Supreme Court will take, again, because of Section 230 immunity in favor of platforms and again providing the immunity. So I'm really curious that in future how it would look like, and if the colleague is saying that we will see how it will look like in Murphy. So I believe, and as Colin was also mentioning, United States is a totally different environment as compared to Europe, especially for election and so. Now, question, when we talk about the DSA, in March 2024, European Commission released a new public guidelines after the public consultation, especially for election, and where they're talking about the systematic risk assessments, generative AI, and so on, but also you added that there is no specific measure which shows that these guidelines are useful or will going to be useful. So I will be interested if you have any guidelines. Third, I would comment on Colin's, when Colin was talking about that this is the disinformation and misinformation in history for 100 years, for 200 years. And there was a study done by Harvard scholar Yonchai Benkler, where he released the book after 2016 elections, commenting on network propaganda, misinformation, disinformation, network radicalization, where he said the proof of an evidence is not proof of impact, where he said that although the Facebook and all these, we are seeing that since the rise of this social platform, the rise of disinformation is also there, but his study showed that the right-wing news was more powerful than the social networking. So these 3 points I would have some insight I would appreciate. Thank you very much.
Thank you. Feel free to, final question right there in the middle. And I'll pause and let everyone just go down and address the questions once we have the final one in.
Thanks. What I wanted to ask about was detection methods for disinformation and deepfakes. So both thinking about the technical methods, so like watermarking or fingerprinting, but also the contextual methods that Maria briefly mentioned in terms of user flagging or figuring out the context in which a piece of political information has come out. And I'm particularly interested because a lot of the panel has focused on the political party's creation of this information, but I think the evidence shows there's a lot of information that is not created officially by a party, but more by activists or followers of parties or kind of fringe grassroots. Thanks.
All right, thank you. I'm going to go, I think, reverse order here and let Colin go first. Feel free to address any of those questions you'd like, and then we'll go down the row.
Yeah, so just very, very briefly, yeah, I think the previous speaker there was talking about, impact, and just because it's there doesn't mean to say it influences people. I think that perhaps reinforces my initial point that there are more people. I mean, this is a huge generalization, but generally, the number of people in our democracies who are persuadable and who are not allegiant to one side or the other has increased dramatically over the last, and this goes back to the 1960s. Political scientists talk about de-alignment, right? Where people do not have the same allegiances to political parties that they once did, and particularly of younger people, right? And so that therefore increases the amount of the susceptibility to deepfakes, misinformation, but also other forms of digital advertising. So I certainly take that point, and I take the point about news as well. And on the point about people on the fringe of the political parties, yes, absolutely. That is a sorry, that is absolutely part of the point. But I think it's incumbent upon those people who are in our political parties and who do have some responsibilities for cleaning up and having responsible political discourse, to calling out not only opponents but also supporters when they see something that's done that is antithetical to proper democratic discourse. And that's simply not happening. If they see it, if they see something that could help their messaging to particular groups of people, then there's a tendency to sort of back off and turn a blind eye. And that's where this debate has also to be situated within the larger problem about profiling the electorate, building databases on the electorate, and using that information for the variety of campaigning tools that are used on social media, email, text, and on the doorstep where that is permissible.
I start eventually with the person in the back, and I'm obviously not a Section 230 specialist. My points were more focused on the distinction between the European right to freedom of expression versus the US right to freedom of speech. But we had similar situations in Europe as well, in particular with the predecessors of the Digital Services Act, the Netzdurchführungsgesetz in Germany, and the debates around that that were misused by the far right in Germany for their purposes. And a similar situation arose also, again, predecessor to the Digital Services Act discussions in Poland, where the former Polish government insisted and started to enact laws to actually re-upload content that the social platforms had taken down, or at least bring in a system that they could do so. So it's not entirely unfamiliar here in Europe too that there are extremes. A little observation that I have no idea whether this is right. I'm not a political scientist, but I felt over the last couple of years in elections that there are some democratic systems that are a little bit more resilient to it, and this is where it's not a winner-takes-all system, but a coalition system, like, for example, in Germany or in Belgium. Maybe the Netherlands has now proven me wrong, I'm not entirely sure, but there seems to be something to that. We haven't spoken about, indeed, the codes of conducts that have been initiated recently to strengthen the measures that the tech companies can take, such as the Tech Accord, which is an international accord on elections, or the Election Code of Conduct that basically supplements the Code of Practice on Disinformation specifically for elections, or the more industry-relevant initiatives such as the Coalition for Content Provenance and Authenticity, which is really also driven by researchers in the AI space to find ways to authenticate deepfakes. Again, I think we are in the situation that we talk about deepfakes as deepfakes in this context, but when we talk about, for example, advertising, then we are talking about AI that is a tool to grade content, and it's a little bit the same thing, and that makes it so challenging. This is sort of this issue that we have a tool here that we want to be as accurate as possible on the one hand and be as creative as possible on the other hand, and that is just a tension that we are dealing with in these spaces. And then I'm not sure what the last question was, but I think it went to this content provenance and authenticity. There are a number of different tech ways to authenticate content, but because I have been focusing a lot on model regulation, I'm very much convinced that data set and model analysis is a way to go, and that we need to have much more openness in the data sets of models. But that is my personal opinion.
Yeah, absolutely. I do definitely want to acknowledge the fact and the roots of Murthy as a very cursed attempt by Texas and other states like that to really attack these policies with COVID-19 misinformation. It was particularly about the veracity of vaccine information, but that's getting a little bit away from the election context. And regardless of how cursed and how a lot of politics and controversy are getting into this, regardless, it does set precedent, and it does get into how we can rule elections going forward and how we can really regulate them. So talking about how the scope of 230 may look going forward, right now what we're looking at is the scope of 230 and whether it only affects when a social media platform or whatever platform that does content moderation, whether or not it's only that safe harbor or whether it protects much larger issues. So that's what we're looking at in Murthy, that's what we're looking at in NetChoice, in several other cases. I'm not the person on our team that does most of our platform governance work, but a lot of our website has blog posts and more information if you're interested in deep diving into the cursed world of 230. In terms of the detection methods for deepfakes, I think watermarks right now are a really hot button topic, particularly in the United States, which is what I'm familiar with. Most legislators are saying watermarks are like the silver bullet, they're gonna fix everything, and like every single AI legislation package that I've seen personally has included some kind of watermarking or labeling or authentication like system. I will say watermarking, it is something. It is better than nothing. It's a Band-Aid solution. I don't believe it's the only way, it's the only thing that we need to do. We need to do several factors, several approaches. And in particular, watermarking really depends on the format of the content. So for example, on maybe audio content, it's a lot more useful to watermark it. There's a system where you can almost do a QR code of random sound noises within the audio content, and someone can read that like a system can read that like a QR code and say, oh, that's synthetic content. And that's very hard to get rid of. It's relatively stable. People tend to download the original file rather than screen recording or doing something like that when they're transferring the data. So in that case, watermarking on audio is a lot more useful than, say, watermarking on text, where it's almost impossible to watermark text accurately in a way that's stable and a way that won't go away when you transform it. So for example, most people copy-paste text out of ChatGPT or other LLMs. And so when you copy-paste text, you get rid of any metadata, you get rid of anything that was in the original platform, and so for that reason, watermarking text is less useful. So I think it's really context dependent on how you want to identify synthetic content, detect it. There's also a University of Maryland study on Google Synth ID, which was an algorithm that detects synthetic content. They were able to place false watermarks. They were able to remove watermarks. They were able to defeat Google Synth ID in several different methods, and were able to mess with watermarks very easily. And with both sides of the technology, both the detection and the creation of watermarks so new, it's a little troubling to see that it's that easy and that quick to defeat it. So on one hand, watermarks are something, they are better than nothing, but I think legislators are focusing on watermarks a little bit too much right now.
Great. And that bell we heard earlier was the 2-minute mark. There is no way I am going to force you all to stay late on the very last panel of the day. So I will close us out with one last thing. I just wanted to give Eleanor a chance for a final word if you would like.
Thank you. I would like to reiterate your words. So maybe watermarks are not perfect, but they are the solution we have right now, which is better than nothing. And of course, for instance, the AI Act allows for a lot of flexibility moving forward in the future to adapt certain measures, to introduce new ways of measuring certain aspects, including this one. But indeed, for now, it's, let's say, the best solution we have.
All right, thank you all so much for joining us. I really appreciate you sticking around. And if you could, please give a round of applause to our wonderful panelists, both here and remote.